Hello everyone, my name is Schroeder and I'm a business attorney here at MPL Law Firm. And today we're going to be talking about the common mistakes we see clients make when forming an LLC. So first and foremost, what is an LLC? An LLC is a limited liability company that's a separate legal entity that separates your business from your personal assets. And it's a liability shield in the event that things go wrong. So for example, we have John Doe. He's really good at cutting hair. He decides that he wants to open a barbershop. He starts an LLC, starts his business. He's doing great, getting great clients, but he accidentally cuts one of his clients. And they get really mad. So they sue John Doe. If he sets up the LLC correct and he follows all of these rules, he'll be protected. So only the LLC's assets will be at risk, right? None of John Doe's personal assets, right? So the first mistake that we see is clients don't form the LLC. So same example, starts a barbershop, he's cutting out of his garage, he accidentally cuts a client gets mad, they sue John Doe, all of his personal assets are gonna be up for grabs because he doesn't have that liability protection, right? The second mistake that we see is that clients don't have an operating agreement when they form an LLC. So first and foremost, an operating agreement is a legal document that dictates how the business is gonna be managed, how you can take money out of the business, who gets what, who operates the business, and what happens in the event that there's a dispute, right? So, for example, we have John Doe, we have Jane Doe. They're both really good hairstylists. They decide they want to open a barbershop. John Doe contributes $10,000. Jane Doe contributes $50,000. If you don't have an operating agreement, you're going to be stuck with state law, and generally speaking, both John Doe and Jane Doe are going to be entitled to 50% of profit. Now, if I'm Jane Doe, I may think that's a little unfair. I put in $50,000, maybe I should get 70 to 80% of the profits, right? So with the operating agreement, you can outline all of that. Another thing too is that in the event, well, you're gonna need a business bank account. When you go to open your business bank account, if you're looking for loans, if you're looking for funding, if you wanna sell your business, the people on the other side are gonna be looking for an operating agreement. If you don't have the operating agreement, people aren't gonna take you seriously, right? The third mistake that we see clients make is that they don't separate their business from their personal finances. So you start a business, you're operating the business, but you're accepting money on behalf of the business and putting it directly into your personal bank account. Or you're buying things on behalf of the business, you're doing expenses out of your personal bank. In the event that something goes wrong, you go to court, there's a judgment against you. The court is most likely going to pierce through that LLC, look at the fact that you didn't have a business bank account, you were operating solely out of your personal bank account, and they're going to pierce through the LLC, tear away your liability protection, and come after you personally. This is called piercing the corporate veil. And generally speaking, judges are going to look at this and say, hey, it looks like you're just using this business as your personal piggy bank. You're not following the proper formalities, they're going to come after you individually. The fourth mistake that we see business owners make. So you've been watching this video, you form the LLC, you have an operating agreement, you're separating your business and your personal finances, but something bad happens and you go to court, you get a judgment against you, and you're still personally liable. You want to figure out why. Oftentimes we see that clients will enter into agreements on behalf of the LLC and sign on their personal behalf. So they sign as John Doe. Whenever you're entering into a business on behalf, entering into an agreement on behalf of the LLC, you want to make sure to sign on behalf of the LLC as a capacity as a member of the LLC to make sure that the LLC is going to be the ones whose assets is up for grabs. The fifth mistake we see is that clients will often forget their annual filing. So depending on whatever state you're in, here in Pennsylvania, there's an annual report that you have to file in the state of Pennsylvania and a fee that you have to pay. If you don't do that, you run the risk of losing your business, of seeing your business being terminated. So we want to make sure to take care of any annual filings, taxes, anything of that nature. The sixth mistake that we see, so coming back to our example, we have the barbershop, and John Doe is making good money. He decides that he doesn't want to pay any more rent to his landlord, so he wants to own the real estate that he operates the business out of. he decides that he's going to purchase that real estate in the LLC that the barbershop is owning. And that's a big no-no. In the event that something goes wrong with the barbershop, not only are the barbershop's assets up for grabs, but so is the real estate itself, right? So you want to make sure to have two separate LLCs, one LLC for the operating business and one for the real estate. That way you have an added layer of liability protection. And finally, the seventh mistake that we see. So your business is doing great. Maybe you formed it in Pennsylvania. You decide you want to go right next door to New Jersey or Baltimore, and you start operating your business there, but you forget to register to do business in that state. That's another way to face a penalty. You'll get major fees, and you'll get in a lot of trouble if you do that. Thank you so much for tuning in. If you have any questions, please reach out to anyone at MPL Law Firm. You edit out those